For a lot of people, the idea of a revocable living trust for their estate plan can seem really confusing. So let's make it simple. I'm Darcel Lobo. I own Dow Law Firm Minority Park. I've been an attorney for 16 years, helping clients with estate planning, real estate, and probate services. So let's just go over what a revocable living trust is. It's a type of estate plan that provides for instructions of what you want to have happen after you've passed away, but it also allows the person that you've named to be in charge, who we call your successor trustee. It allows them to make that happen. They can liquidate assets, pay debts, and make distributions as you've outlined in that revocable living trust. The biggest pro for my clients who want to use a revocable living trust is that it avoids probate. It also maintains privacy. It keeps your estate out of court. If you have a will, that's a perfectly valid way to distribute your estate, but just know it will go through probate and it becomes public record. So anyone can look up your estate, see what your assets were, see what your debts were, and how much your heirs received. So if you want to go with the revocable trust option to, again, avoid probate and maintain that privacy, keep your estate out of court, there's a few steps involved, but it doesn't have to be difficult. It doesn't have to be overwhelming, and we're here to help you every step of the way. So first, what we do is we create the trust for you. You sign it, and during your lifetime, you maintain the trust. So if you want to buy more assets, you want to sell assets, whatever you want to do, you still do so. You are one of the same as your trust. During your lifetime, you want to make sure that you fund your trust with your assets. So we help you do that when we set up the trust for you. But after we're done, you want to ensure that if you buy future real estate or you open new financial accounts, that the trust is named and is holding those assets for your trust estate for you to manage during your lifetime. That's what allows it to avoid probate, is that it is owned by the trust itself. In the trust, you name someone again as your successor trustee. So upon your passing, they step into your shoes. They make those distributions as you've outlined in your trust. A few takeaways about the trust itself. Both a will and a trust are an estate planning tool, but they are different. A will functions differently in that it's a set of instructions, but it doesn't allow for anything to actually happen without it going through probate. So again, that court oversight of the distribution of your estate according to the terms of the will. So the will says, I want this person to be my executor. I want, these assets to go to this person. I want this much money to go to that person. And that's great. But in order for it to happen, it has to be overseen by the probate court. Whereas with the trust, you outline who's in charge, who receives what, and that just happens by your successor trustee without having to go to court. That's the biggest difference between those two options. But with the revocable living trust, it does not have to be overly complicated. Now, there can be some more complex situations. If we're doing tax planning, if we have minors to provide for, then there's going to be some additional planning that needs to be done with your trust. But it doesn't have to be overwhelming. I cannot tell you how many times I have clients come to me with a prior trust from 20 years ago, 30 years ago, and they have no idea what it says. They have no idea what it means. So with all of our trust plans, not only do we draft it in a way that is, easier for you to understand, we provide you with a short summary in plain English language of what this provision means, what that provision means. And so we break that down for you because there is some legalese that has to be in the trust, right? That's required. But we give you an overview, a summary of your own trust so you understand it. I want my clients to know what their estate plan says, who's in charge, who receives what, why we did this, that, or the other with their trust and that language that's in it. I want you to understand it. I want to break down this overwhelmingness, this misconception about what estate planning is, or that only someone who's really wealthy needs an estate plan. Like, no, everyone needs an estate plan. If you are over 18, you need to have an estate plan. And for a lot of my clients, they'll come to me and they say, we've been putting this off for 10 years, 20 years, or, we wanted to do this when we had our kids and our kids are now adults, right? And we need to get this done. And that's okay. Like, we can get this done for you now, but we can only do it while you have the competency to do so, right? And so if we wait until you need an estate plan, right? You have an illness or there's Alzheimer's, dementia. If you don't have capacity or the ability to understand and execute an estate plan, whether it's a will or a trust, we can't do it for you. Or when it comes to a power of attorney, which a lot of people overlook sometimes too, like we can't do those things if you wait until it's actually needed. We need to do this preventatively ahead of time before it's needed. We need to have that plan in place. And I tell my clients all the time that having a well thought out estate plan completed is one of the best gifts you can give to your family, to your loved ones, to your children, to extended family, to friends, to whoever you want to provide for. That's one of the best things you can do for them, because at a time when they're dealing with the loss of a loved one, the last thing that they need is a set of legal problems on their hands. And so by having an estate plan in place allows for all these decisions to already be made, who is in charge, what's going where, it's all outlined, and they just have to follow what your estate plan says, whether it's a will or a trust, right? We want to have a plan in place. So if you've been putting off getting your estate plan done, you've been unsure about doing a will or a trust, and I understand that calling an attorney's office and talking about what happens when you pass away, nobody wants to have that conversation. That's not a comfortable conversation to have. When I did my own estate plan with my husband, like that was a very difficult thing to do. So I understand that. I have 2 teenagers myself. And so, but it's important that we do it to protect our families, to protect our children, to protect whoever you want to provide for. And you've worked really hard to acquire your assets, right? We want to protect them and make sure that they go to the right people. Because if you don't have an estate plan in place, I'm here to tell you that the state of Washington has one for you. And a lot of times, it's not what you want it to be. So if you need help getting your estate plan done, you're ready to get that done, you want to meet with me to talk about your estate plan, what that looks like, I'd be happy to see if I can help you. I'll have our contact information listed below for you, our website, our phone number. We have a lot of resources on our website and blogs and FAQs. I have a whole library of videos on this channel here for you for you to become more educated and more informed about estate planning and what that looks like and what options are available to you. We have transparent flat fee pricing. Our pricing is on our website. Again, I'll have it linked down below. There's no surprises as far as what it's going to cost. I don't charge you by the minute for the phone calls and the emails. Our estate planning services are a flat fee. If you need to give us a call or send me an email, there's no additional charge for that. So again, contact information is below. I'd be happy to see if I can help you, and I'll see you in the next video.